Welcome to Strictly Money at the News Forum, where all voices matter. I'm your host, Saijal Patel. It's Financial Literacy Month here in Canada, and as part of that, in today's show, we are going to discuss estate planning and, in particular, wills. Having a will and an estate plan is arguably one of the most important things you can do for yourself and your family, because you decide how your assets will be distributed. You decide who will care for your minor children. You can minimize taxes and give more to your beneficiaries. And you can help your loved ones avoid a lengthy battle in court. And yet, having an estate plan is often treated as an afterthought. Only half of Canadians have a will, and only 40% have powers of attorney drawn up. For those younger than age 35, that number drops considerably. Even those who have wills often forget to update them when a major life change happens. Aaron Edgar is an estate planning lawyer with Edgar Chana Law, and he joins me now to discuss how to make sure you have your will and plan set up properly. Aaron, thanks for coming on the show today.
Yeah, it's my pleasure. Happy to be here, Saijal.
I look at these stats and the number of Canadians who don't have wills and may not even have it set up the right way, and it still surprises me. Why do you think so many people don't have one?
Yeah, I always talk about this. It's something that's very, very important to have, but it's not necessarily urgent for people. So people think, hey, I'm going to live, and maybe they don't want to compensate their own demise. They don't want to do the planning. It's an uncomfortable thing to maybe talk about. It's an uncomfortable thing to sometimes plan and discuss with family, because you have to have those difficult discussions as well. So I think for a lot of people, that's the hard part, right? It's having those discussions and kind of contemplating their demise. So some people are superstitious about these things as well, right? They don't want to talk about death, but these are important things to talk about. Death and taxes, what we're going to talk a lot about today, I guess, right?
Yeah. I know one of the reasons I hear often is that, I'm still young. I don't have a lot of assets. I don't have a family. And the work and the cost to get a will done is sometimes not worth it, because they think, well, there's a straightforward formula that the government will follow. It seems like a reasonable argument.
Yeah, I mean, for some people that formula may work, but part of it as well is things may not be efficient from an administrative perspective, and what happens with your estate in terms it could take you a while to to get your estate administered. If there's no one there who's going to be the executor, if you don't have people appointed, it throws up questions. Who's being the person who acts for you? What's going to happen to your assets? Where do they go? And if you're not making those plans, or you don't know what the default rules are, you may not be comfortable with with dying without a will. So it may be worthwhile when you have assets, if you have family that you're going to leave behind, that you put that plan into place to protect your loved ones, really, right?
Yeah. So when you don't have a will, it's considered intestate, and the court or the probate court will decide how you distribute those assets. In your experience, do they get it reasonably right most of the time?
Well, usually it's there to protect the family. So in most cases, the nuclear family, yeah, that works out great. Things go to the spouse, things go to the children. If there's minor children, that's when things can maybe go aside, because the law provides that some of the estate goes to the spouse, some goes to the minor children, and if the minor children are inheriting something, that money gets held by the court rather than going to them outright. So when you have minor children, those rules, those intestacy rules, they may not be the best fit for your family, right?
Yeah. So do you need something formal done? Because I often hear, you know what, I'm just going to write something down on a piece of paper or on the back of a napkin. Does that work? And does it work across Canada? Because I know jurisdictions are different.
Yeah, so a lot of jurisdictions allow, it's called doing a holograph will, which is you write down your instructions on paper, and yeah, that is an effective will. But sometimes if your estate's even somewhat complicated, the cost to interpret what you wrote down and what you meant, that can be more expense to your family, and it may not necessarily be the right fit for you. So there's even a classic example. I think it's someone passed away, or they were dying and they're underneath the tractor fender, and they wrote their will on the tractor fender with with a rock, and that was considered a holograph will. So you can do a will that way, whether you should or not. That's typically a bigger question, right?
Yeah. Let's quickly talk about probate fees. We only have about 30 seconds left. A lot of focus is on avoiding it. Does that make sense?
Yeah, I mean, you do want to try to minimize the probate fees you're going to pay, but you don't want to do that maybe at the expense of maybe making some poor decisions. Like a lot of people, you do joint assets, they may not make the best decisions. People may make decisions with their beneficiary designations that may not be the most tax efficient. So there's a lot of planning around that you have to consider whether using joint accounts, using beneficiary designations, whether those things actually suit your purposes, and whether avoiding probate taxes may be the biggest concern for your estate.
All right, we're going to take a quick break and we'll continue this conversation. Welcome back. I'm here with estate planning lawyer, Aaron Edgar. Aaron, before the break, we were talking about probate fees. Like I said, a lot of focus and energy on avoiding it. Why do they exist in the first place? This is always an interesting question. And how does one go about minimizing those fees? We actually have a board, so we'll bring that up.
Okay. Yeah, probate tax, usually it's a small tax. It's 1.5% in Ontario. Other provinces are somewhat similar, but it's a tax you pay. You pay it to the court when you have to go and prove the will. So why do you have to prove the will? You're really proving the will. So the banks or the real estate lawyer, they know they can deal with you as the executor, and they have comfort that you're the right person. You're the person that's appointed. So they're comfortable to deal with you. They're comfortable to set up the estate accounts and transfer real estate on your instruction. So when you're looking at that chart, it talks about basically different asset classes, right? So assets that you hold jointly with a spouse, which is in that far right column, they pass to the surviving spouse outside of your will, outside of the probate tax regime. And the other things that pass outside the probate tax regime are things that flow by way of a beneficiary designation. So, your RRSP, your RIF, TFSA, insurance, some pension plans, those assets flow to the named beneficiary outside of the will. So this is kind of important for people to understand, because people sometimes say, hey, I have to get a will. But really, what you need is an estate plan that talks about all your assets and how all your assets flow. So you need to understand what you're doing to minimize probate tax, is also to have an efficient estate administration. So all these things fit together. And like I said, you may not want to do too much to avoid probate tax when there's other concerns as well. So a lot of times with joint assets, people think, oh, I'll just put everything joint with my children.
Yeah.
But the laws changed as of 2001. If you have adult children, you put assets joint with the adult child. There's a presumption that those assets don't flow directly to the adult child. They form part of the estate. So there's been lots of fights where people will put joint accounts with one of the children. The other children are beneficiaries of the estate, and they say, well, hey, maybe that joint asset, that should have been part of the estate as well. It shouldn't have flown to the one child through the joint account designation or joint with survivorship on the real estate. So these fights happen, and it's not necessarily clear. A lot of people don't understand what it means to put assets in joint when it comes to estate planning.
I know one of the issues that I have seen is that, if someone does pass away, it's like everything freezes up. So you want some ability to be able to, for someone, say, the beneficiary or the executor, to be able to still pay bills. And that's one of the reasons why they create these joint accounts in the first place.
Yeah, I think it makes sense to do that maybe for a certain, like your checking account, maybe you have a certain amount of money in, but to put a large asset and have it flow that way, it may not be the best for your estate. And the banks are flexible. They do allow withdrawals to pay funeral costs, to pay your lawyer, to pay the probate fees to the government. So assets don't necessarily freeze up, but the banks don't want to release everything until they have that that proof, the probate, basically, that they're able to deal with the executor.
Aaron, when it comes to wills, I would say one of the most important decisions that you can make is who that executor is going to be. Can you walk us through what sort of qualifications and characteristics that they should have? It's not like you just pick anyone, like a family member, or sometimes that doesn't make sense.
Yeah, the first discussion I usually have with clients is, who does the executor actually work for, right? They're carrying out your instructions for the will, but they're working for your beneficiary. So sometimes, and because of that, it makes sense to maybe for one of the beneficiaries or some of the beneficiaries to be named the executor. But also parts that you want to consider with the role is, that person has to be somewhat financially savvy, right? Because if they're responsible for those beneficiaries, their share of the estate, they have to be keeping good books, because those beneficiaries could come back after the executor and say, hey, you didn't manage the estate properly. So they have to be somewhat financially savvy. And the other thing too is, convenience, right? So you can't have someone halfway across the country necessarily administer your estate. I know you can do a lot of things remotely, but the banks still want to see a wet signature. The lawyers still usually want you to, sign the probate application. Some of these things can happen remotely now, but for managing estates, managing the house, which is the big one, it helps to have someone nearby to do it. In Ontario, for example, you also want to avoid bond requirements in the court. So you want to make sure that you have an Ontario executor if you have an Ontario estate. So that's another important consideration for people.
Does it make sense to have a number of executors? Because I've seen situations where they're like, I have 3 kids, I'm going to name them all as executors.
Yeah, naming all three can work, but they all have to get along and they all have to work together, right? So that does come down to, again, where if you have 3 children, maybe they're all 3 executors, so they can get along. That works great because then they're all looking at the books together. They're all making decisions together about what to do with the money. So, it's not one child fighting with the other one. If one's made executor, they're all working together. But it can sometimes be a case of too many cooks in the kitchen as well, if there are too many. So sometimes it doesn't work. So it's a difficult decision sometimes whether to put multiple executors together because
Right.
they do have to be able to work together.
Welcome back. I'm here with Aaron Edgar, who is an estate planning lawyer. Aaron, before the break, we were talking about wills and executors. Let's switch gears and talk about updating wills because we know it's important to do that, especially when there's a major life change. Sometimes it's not realistic to do it, every time maybe someone has a child necessarily. But when is it an absolute must?
I think it's an absolute must. Maybe, having children is one thing, and you have to look at the will and see what the will says. So I'm usually encouraging my clients to pull the will out, look at it every, at least at the minimum every 3 to 5 years to make sure the appointment still makes sense, right? And the beneficiary still makes sense. Those are the biggest pieces for people. And you hit different life stages as well. A lot of people, having kids, they need maybe trust to protect the children. They need to have trustees in place when the kids are getting older. Maybe they're able to step in some of those roles like executor. That's a life event for them that, they don't need a third party trustee. They can have the kids acting as the executor and trustee under the estate when they reach a age of majority or maturity.
Yeah, that's actually an interesting point. When does it make sense to have a trust for children?
I think whenever they're minors, and we usually talk about this with clients, is when are kids mature nowadays, and that's the big question, right? When you have toddlers, when is my child actually going to be mature that they can manage money, be responsible? So a lot of time, maybe clients are putting trust in place, maybe until age 25, maybe till age 30, when the children they think may be mature enough to be able to handle the money at that stage. So usually the trusts are fully discretionary, right? The money is there for the child's benefit, but they're only getting the outright everything and full access to the funds at that certain age.
Yeah. So we know one time that it is important is when there is a change in marital status. Either, it dissolves or they get remarried. Walk
Mhm.
us through some of the common mistakes that you see.
Yeah, I mean, I just think, when you're having those change in relationship marital status, it is a big event and you do need to get your wills updated. Normally, you're dealing with your family law lawyer to set out, what the rights are when you separate, but you also want to make sure those things are clear under your estate plan as well. So if you're separating, your will probably still names your spouse, and maybe that's not the plan you want. Maybe you want to skip over, make sure things are just there for the children. Blended families are another situation, right? Where you're maybe remarrying. Maybe you want to make sure the estate is there for your children from the previous marriage, and you're maybe not as concerned about everything going to the spouse when you're both, financially independent at a later stage in life, right?
There's a belief that once you have a will in place, it is going to be done just that way. Now, I know I've personally seen some situations where it is contested.
Mhm.
What do people have to be aware of?
So there's a lot of different claims people can make under estate. So, the big ones that challenge wills are, undue influence. Was the person under influence from some other person to change the will? Were they being forced to do it? And, was the will executed validly? Did the person have capacity, right? So sometimes there's concerns about whether the person had mental capacity when they made the will. So those are some of the bigger ones to challenge wills. But there's also claims that spouses or common law spouses can make against the states, like under the family law act. They can either take under the will or take as if they had divorced on the date of death. So that's one claim against an estate, and usually your family law lawyer is navigating that with you as well. And common law spouses as well, they can make a claim for dependent support if they were being supported by the spouse and the will didn't provide for them. So those are some of the most, I think, common claims you see when wills are contested.
Let's talk about power of attorneys. which is actually separate from wills, but also something that a lot of people don't do. What's one or two things that people have to think about when getting it done?
Yeah, I mean, usually when people get wills done, they get powers of attorney done as well. And I tell clients, power of attorney is the most important document you're going to need because, and people think, hey, I'm not going to need, I'm not going to lose capacity. But the truth of the matter is, there's a really high chance that you will not have capacity, at least for a period of time before you pass away, right? And in that time, you need to make sure that your dependents are cared for, right? Can your bills be paid? Can your family be cared for if you don't have capacity to deal with your bank account, your investments, things like that? So it's a very, very important document to have for that reason.
Yeah, and or you can be in an accident or get
Exactly.
sick. Yeah. So is there something that they need to think about, or who should actually have that power of attorney? Typically, the spouse.
Typically the spouse, yeah, in the nuclear family, but it's a similar decision to executor, right? They have to be financially savvy, right? They have to be someone who you trust to manage your assets, but normally it is the spouse first, and then usually you want to have a backup as well, just in case something happens to both of you, right?
Yeah. Okay. We're going to take a quick break, and when we come back, I want to get your thoughts on doing it yourself. Always an interesting conversation. Welcome back. Our guest this show has been estate planning lawyer Aaron Edgar. Aaron, who should hire an outside party or trustee to be an executor? Because sometimes it doesn't make sense to have someone be it.
Yeah, I mean, sometimes you need professional trustee services, right? And I mean, one of the situations sometimes when you have younger kids, if you're going to have a trust that's going to be going on for a long period of time, maybe there aren't suitable people who are there who are able to act for the next 20 years. So sometimes if you have trust in your will that are going on for a long period, you may want to have a professional trustee who's going to be there. There's other situations too. If you don't have any other alternatives, right? You don't have any family or other friend or someone that you trust to do the job, then maybe a professional trust company is the best choice for you, right?
Yeah. So do-it-yourself will kits. They're becoming quite popular. And I think from what I've seen, if you have a simple estate and you can't afford a lawyer, it's an option. What I have always said is the caveat is you still have to know why you're doing what you're doing, and that there's consequences, so you don't leave room for interpretation. What are your thoughts on doing it yourself?
I mean, some of these do-it-yourself kits, they work for you, but you know what? If your life gets a little bit more complicated, you may not know if that do-it-yourself will actually suit your situation. So, yeah, you'll have a will, but maybe you didn't get the right advice, and maybe you're not getting a will that actually suits your situation properly. So, right, for younger people, simple family, simple assets, maybe that works out for them. But maybe they're not getting the right advice on making those decisions, right? So filling in a form that says who's your executor and putting a name down is maybe a little bit different than getting the advice on who should be the right person to be your executor and having that discussion with your lawyer and getting someone to give you advice on sometimes making some of these best decisions about these really important roles and what the consequences are, right?
And the role of a financial advisor, I think sometimes they do play a very important role.
Yeah, financial advisors are really, they sometimes form a big piece of the puzzle because that's where the family's going to understand the investments and the assets to say, hey, what do we do, and what's the best way to manage them. So a lot of times families are continuing on with the financial advisor for that continuity and getting that financial advice to support the estate and trust assets as well.
Yeah. When you update a will, how does someone know that it's the final will? And what I mean by that is also, well, there's that piece, but also just making sure that the documents are in place. Because sometimes people forget about that. They're like, I've done a will, and somebody doesn't know about it.
Yeah, yeah. So it's really important, and the onus falls on you, the person who's making the will, to make sure you're talking to your executor, making sure your executor knows that that responsibility is falling on them. Where do they find the document? Where do they find the assets? Right. So the will is one piece of the puzzle,
Yeah.
but the executor also has to know, where do I find all the assets? Right. Because if they don't know, if something falls, like, right, if there's a property that they're not aware of that falls into disrepair or something happens to it, that executor can be liable. Right. So the executor wants to make sure they know how to do the job. They know how to find all the assets. So it's very, very important on you, the will maker, to make sure you're keeping your executor in the loop about what the job entails.
So, Aaron, what do you suggest? Should people have a physical sort of spreadsheet with everything on it? Uh, put it on the computer, make sure somebody has the password. Are there pros and cons to either way?
Yeah, I mean, doing electronically is one option, but I mean, the will is unfortunately in paper. So sometimes I say to clients, keep this stuff with the will, right? Keep
Yeah.
do a printout of your assets and keep that with the will. With our clients, are filling out a questionnaire, right? So we're always having that updated questionnaire. We're keeping that in our file. So when the clients are, coming back to us or the family's coming back to us, we said, here's the list of assets that, were there when the will was made, right?
hmm Well, we only have about 30 seconds left or so on the show. Final thoughts for those of people who are thinking about getting their estate planning in order and they're procrastinating. What message would you send them?
I'd say do it now. There's no better time than the present. You don't know what the future holds, so make sure you're protecting your family, looking out for them, looking out for their future to make sure you're getting this plan in place for them.
Yeah, and have your team, I think, around you too, right? Sometimes it's a lawyer. You can do it yourself, but lawyer, financial planner, maybe your insurance agent. There's a few people that play a role in this.
Yeah, there's a lot of pieces.
All right. Thanks for joining us today.
Thank you very much.
Appreciate it. Aaron Edgar of Edgar Chana Law. Well, that wraps up this edition of Strictly Money. Catch our special financial literacy episodes for the month of November by subscribing to the News Forum Facebook page or follow me on LinkedIn at Saijal Sage Wealth Consulting. Stay well, stay wise, and stay wealthy. Thanks for watching.